Good afternoon, everyone. Hope everyone can hear me. So without any further ado, let's get started. We're going to cover this afternoon the following topics. We're going to talk about the applicable provisions on the protection of operational personal data at Eurojust. We're going to talk about the case management system, which is the database of Eurojust to process operational personal data. We will deal with interactions with member states, and last about interactions with third states and international organizations. So first of all, talking about the applicable provisions on the protection of operational personal data at Eurojust. The legal framework which applies to the protection of personal data at Eurojust has been in place since the 12th of December 2019. So you may wonder why this date? Well, this is simply the date when the Eurojust regulation started applying, and also, as we will see, Regulation 1725, which started applying on the same date to Eurojust. It's a date that we had to negotiate with the EU legislator to make sure that our data protection regime would remain one and only, and would start applying all at the same time, and not piecemeal, which would have made the situation simply impossible. So this data protection regime is composed of several layers, as you can see. We have the Europol regulation, but we also have Article 3 and Chapter 9 of Regulation 1725. So how do the two work out together? Well, as we will see, the Chapter 9 of Regulation 1725 is considered lex generalis, and the Eurojust regulation are lex specialis. So this is how the interaction between the two regulations. So you may wonder what this Latin jargon means exactly. Well, what it means is simply that the general principles are set out in Chapter 9 of Regulation 1725, and all the specific provisions which apply to Eurojust only, of course, are set out in the Eurojust regulation. Of course, in an ideal world, all these provisions should be aligned, but in case of inconsistency, perish the thought, Chapter 9 of Regulation 1725 prevails, precisely because it sets out these general principles. And the provisions, again, of the Eurojust regulations are only supposed to specify these general principles, which are set out in Chapter 9 of Regulation 1725. So this is basically the interactions between the two regulations. There is, to call a spade, a hierarchy of norms between the two regulations. And clearly, these provisions of Chapter 9 of Regulation 1725 prevail over the specific rules which are set out in the Eurojust regulation. So this is an important aspect, of course, of the data protection regime of Eurojust. So this is, in a nutshell, a table about the applicable regime at Eurojust. Again, to your left on the slide, you can see all the general principles which are set out in Chapter 9 of Regulation 1725. To your right, you can see the Europol regulation, which specifies, once again, these general principles. In addition to that, very importantly, we have rules of procedure that you can see in the center of the slide at the bottom, which deal with both operational personal data, but also administrative personal data at Eurojust, and which come in addition to the two regulations. So as you can see, we piled up provisions basically between Regulation 1725, the Eurojust regulation, and in addition, the rules of procedure. And you have to look at all these provisions to get basically the applicable law on any specific point. So regarding now the supervisory regime of Eurojust, the European Data Protection Supervisor, the DPS, is our new external supervisor. Before the 12th of December 2019, it was the joint supervisory body of Eurojust. There was a different joint supervisory body at Europol as well. So the two should not be confused because there are big differences between the two. But again, since the 12th of December 2019, the EDPS has taken over from the GSB. Very importantly, there is no cooperation board at Eurojust. This is a big difference from Europol. You heard Daniel explaining to you that this cooperation board at Europol is part of this data protection regime. This is not the case at Eurojust. It was the case initially in the initial draft proposal for a Eurojust regulation, and it was removed during the negotiation from this earlier draft. So as a result now, Europol is the only EU agency which has a cooperation board. And I don't think I would step on Daniel's toes by commenting that during the next amendments of the Europol regulation, I would bet that this cooperation board, which is an oddity, will disappear. Now, we also have at Eurojust, since we don't have any cooperation boards, what is called coordinated supervision, meaning that whenever the EDPS deals with operational personal data, it has to confer with the data protection authority of the relevant member states. And actually the opinion now of this data protection authority of the relevant member state is legally binding on Eurojust. The EDPS also has the possibility to escalate the issue to the European Data Protection Board. So there are two provisions which govern this mechanism. One, interestingly, is from Regulation 1725. The other one is from the Eurojust regulation. So we have a mechanism in place, basically, in order to deal with the fact that the operational personal data comes from member states and the need to confer with the relevant member states whenever necessary. Since, again, we do not have any cooperation board at Eurojust, so this is the mechanism in place. And chances are that when the Europol regulation will be amended, a similar mechanism will probably be put in place. So, again, the joint supervisory body of Eurojust disappeared, after the 12th of December. So there are some discussions ongoing as to whether their expertise could be used when it comes to coordinated supervision, their skills, since they have been provided this external supervision of operational personal data at Eurojust for many years. These discussions so far have not gone anywhere, so I don't think that, realistically, the members of the joint supervisory body will be used in the near future to provide this coordinated supervision and will be involved. We may think that this is too bad and this is regrettable, since there was a lot of expertise there which has not been transferred, basically, and it's not being used. But that's the new regime which has been put in place. So, very importantly about Chapter 9 of Regulation 1725. The idea of this chapter is to provide a level playing field for all the relevant actors in the sector of law enforcement. The only problem is that in practice, this chapter applies only to Eurojust and to Frontex. In due time, it is meant also to apply to Europol and to the European Public Prosecutor's Office. So therefore, when the time comes to apply to the four relevant players, but again, this is not the case at the moment. For the time being, it applies to Eurojust and to Frontex only, which is of course a problem. However, Regulation 1725 provides already that there will be a review mechanism by the 1st of May 2022 at the latest, and therefore this extension of the application of Chapter 9 to the other two actors will be considered then at the latest. But I mean, hopefully it will come before this time, because of course when the idea of a chapter is to establish a level playing field and you only have two of the four relevant actors which are included, it is problematic. Now, let's talk about the case management system of Eurojust, which is again the database that we have in order to process operational personal data at Eurojust. This is the one and only tool that we have. but all the operational personal data must be processed in the case management system. There is no other tool, and it's not allowed at Eurojust to process operational personal data outside of the case management system. So as you can see, this is a very important database to us. So this slide is about the life cycle of a case at Eurojust. Everything starts with a national member opening what we call the TWF, a temporary wake file, in the case management system. And after you have on the slide the various possibilities which are offered to national members in order to do what they need to do in order to provide services to our clients, who are the prosecutorial authorities of member states. So what are these various actions? For instance, you have the possibility to organize a coordination meeting. What is a coordination meeting? Well, it's simply a meeting of all the relevant member states and their prosecutorial authorities who are represented during this meeting in order to deal with the case. The national authorities can also be involved. So to be very clear, the national authorities dealing with the case would be invited to Eurojust in order to discuss the case, but not only discuss, of course, but take some very important decisions for prosecuting the case. So I can guess, which question could be coming up, which is, what about the pandemic now and the organization of these meetings? Well, I would be glad to reply to my own question, then that these meetings can be organized virtually, and they have been over the last few months. So we have all the IT tools in place to keep going, thank goodness, because the Commission of Crimes did not stop, as you can imagine, and to the contrary, actually, we had to deal with new types of crimes with the pandemic, so we have this possibility of organizing some virtual meetings. Now, in addition to coordination meetings, we also have the possibility to organize some what we call coordination centers. What is a coordination center? It's simply a day of operation for all the prosecutorial authorities in a given case. So Eurojust then plays the role of hub, basically coordinating these operations from Eurojust, and during this day, people can be arrested, people can be detained, goods can be seized, cars, drugs, you name it. So we do that on a regular basis, and that's a very intense day of work, as you can imagine. Europol can be also associated during these days of action. It has been done on quite a number of cases. So this is a very important tool for us, these coordination centers. We also have joint investigation teams, which is a different animal altogether. It has its own legal basis, but that's also very important. It allows prosecutorial authorities of member states to work on the case together, hand in hand, and to decide, with an agreement, so a contract, basically, which is concluded between these authorities, how to investigate the case, and also on the prosecutorial strategy. So it goes quite far, depending on how far the authorities want to go. I mean, usually the practice is that when authorities work together for the first time, they have quite a conservative approach to the joint investigation team, but when they are used to work together, and I mean, we are talking also about the humans involved there, they may decide to go further and sometimes to intervene on the territory of a state together and arrest together some suspects. So as you can see, these joint investigation teams can go quite far, but this is also a very important tool to us. So it gives you an idea about the life cycle of a case at Eurojust. So now focusing more on the IT aspects of the case management system, there are some other tools which are related to it, like the case information form. The idea of this form, which does not contain any personal data whatsoever, is to retain the know-how of Eurojust about a case. So it's about creating a kind of internal case law, if you like, about how a case has been prosecuted thanks to Eurojust, the lessons learned, the best practices, the errors made as well, which mistakes were made in order to be smart enough to make new mistakes and not the same mistakes over and over again. So this is the point of this case information form. In addition to that, we have secure network connections with member states, as we will see later on another slide. Those connections have been established with 14 member states so far, not all member states, unfortunately, but the idea is, of course, to provide, as secure a connection between Eurojust and our clients. We also have the JIT funding portal, which is, of course, a lot more specific. It's about how to finance joint investigation teams. These joint investigation teams, once again, are a wonderful tool. They work. The problem is that they are costly. So that's why we need to have funding in place, and member states need to apply to these fundings. So there is a whole scheme around that, and we have a specific tool for that. So again, regarding the case management system, all the various tools that we have available, coordination meetings, coordination centers, joint investigation teams, everything all the operational personal data must be processed through the case management system, also for these tools. There's no exception for these tools. So this is, on this slide, you have a description of the primary functionalities of the case management system. The purpose is, of course, to store securely all the operational personal data that we have, but also to monitor the information. We have some very interesting functionalities, for instance, some search functionalities, which work quite well, even for attachments, so which is quite an important aspect. So again, everything is done automatically in the database. We have also the automatic link detection, which does not always work so well, unfortunately, but it's done on a daily basis, and it provides the national desk with possibilities of links between the cases that they deal with and other cases. So they have to be reviewed. And very importantly for us today, of course, the case management system is a perfect example of privacy by design and privacy by default. So it is meant to implement all the applicable provisions on the protection of personal data, which are enforced at Eurojust for the storage, for the notification of the actors as well when it comes to time limit reviews. So that's a very important tool for us in the Data Protection Office. So what is the structure and the content of this case management system? Well, there is an index which is separate from the TWFs that I referred to earlier, these temporary work files. So the structure of the database allows the owners of the data, which are the national desk, to share this data on a need-to-know basis. There is a high level of granularity in the case management system, which allows the case owner to share the whole TWF with another desk, if it's justified, if it's necessary, or to share only the relevant data, for instance, the data on the victim or the data on the suspect, but not the rest of the data, because it's not necessary, simply because the other desk doesn't have this need to know. So they have, the national members have the possibility to take, boxes to share, to decide to share under their own responsibility, of course, some data, but not others. So that's also a very important aspect of the case management system. So I've already talked about the case information form, the JIT funding portal, and the secure network connection, which are meant to link us to the member states. So I will not further dwell on that unless you have some specific questions, of course. And we will look now at interactions with member states. So this part of the presentation is meant to take you by the hand through the life of a case at Eurojust. So how does it work in practice? Well, very often the national members receive the case from their domestic authorities by email, which is why it's so important to establish a secure connection with our clients. If it's not received by email, but if it's received, traditional way with hard papers, then hard copies, sorry, then of course the idea is to scan these documents and to turn them into electronic form, and then to drag everything into the case management system, since again this is the only place where we are allowed to store operational personal data at Eurojust. So whenever they receive these documents, national members must then open a temporary WAC file, which is the beginning of a case at Eurojust. What happens next? The national members, or it can be done, of course, under their authorities by their assistants or even their secretaries, must create this TWF and therefore insert all the personal data into the TWF. It's extremely important, of course, because it allows to then search the database and detect possible links between cases. So, of course, depending on the duration of the case at Eurojust, it can be quite frustrating, because inserting all this data is time-consuming, of course, and after a few months, once the case is over, we need to delete this data from the case management system, simply because there is no point keeping it, and we would not be justified keeping it, unless there are some exceptions, of course. But this is a very important work which has to be done really properly. So next, as I said earlier, depending on the operational needs, national members decide to grant access to one aspect or the other of the case to their colleagues, depending on their involvement, depending on their need to know. Next, they have the possibility to organize coordination meetings, which are convened by the college. So national members and their domestic authorities participate in these coordination meetings. Europol also has the possibility to join whenever it's justified. Coordination centers can also be organized in order to facilitate the collection and exchange of operational data among the judicial authorities in real time. So this is a day of live action in which a lot happens. As I said earlier, arrest warrants can be implemented, searches, seizures in different countries. There is a video which has been made available in the material here about a coordination center. So it's meant to give you a very concrete idea about how it works in the coordination center and what happens. I really encourage you to take the time to watch this video. It's not very long. It lasts a few minutes. If I remember correctly, it's like 6 or 8 minutes, but it's really worth it in my view. And also you can pay attention to the comment which is made towards the end of this video by the relevant, the national member, for Spain, who says very clearly that Eurojust doesn't deal with its own cases. We're a service provider, basically, and all the operational person data that we process, for our clients who are the member states, the prosecutorial authorities of member states. So I think it's quite an important comment. But if you have the time to watch the video before the end of the seminar, and you have questions about that, we can talk about them, of course. Now, turning to interactions with third states and international organizations. Well, here I would say the situation is a bit similar to what Daniel has described earlier, which is that at Eurojust we rely on the cooperation agreements that we have concluded so far with third states and international organizations. Since indeed there is no adequacy decision concluded by the Commission on the basis of the Law Enforcement Directive. So we're a bit stuck in this situation. Now, an important point for the workshop tomorrow, we also have memorandums of understanding, so not cooperation agreements. Big difference between them is that with memorandums of understanding, Eurojust cannot share personal data, cannot exchange personal data with the international organizations or third states. We have one in place with Interpol. So this is just a footnote in view of the workshop tomorrow. This is a footnote which is meant to assist you tomorrow. So we have signed cooperation agreements which allow the exchange of personal data with 12 third states. This is the list. And we are stuck in this situation now because just like Europol, we no longer have the power to conclude new cooperation agreements with third states. So we are stuck with the list which is before your eyes. This power to conclude cooperation agreements has been taken over from us by the Commission. So this is the possibility for the Commission to conclude to issue adequacy decisions about third states on the basis, again, of the law enforcement directive, bearing in mind that the Commission has not done so yet and has not shown any signs to be very active in this respect, to our great frustrations, to be very honest. Now, let's focus on what we have, these 12 cooperation agreements. As you can see, there has been a rush in the last 2 years, so to 18 to 19, to conclude new cooperation agreements, because again, we knew what would be coming, which is that we would be stuck with this list. Therefore, we really hurried and we pushed third states to the extent we could in order to finalize these agreements, because since the 12th of December, we no longer have this option. Now, very importantly, in all cooperation agreements which are in force, there is a provision giving the possibility for the third state to post a liaison prosecutor at Eurojust. So again, these cooperation agreements provide the legal basis for the third states to establish a liaison prosecutor at Eurojust, meaning, to be very clear, that without a cooperation agreement, we cannot have a liaison prosecutor at Eurojust. It's only if we already have a cooperation agreement in place that the third state can trigger this option of posting a liaison prosecutor at Eurojust. And as you can see, a number of third states have done so. Norway, the US, North Macedonia, Switzerland, Montenegro, and Ukraine. Now, of course, it's also an issue of workload. I mean, first of all, a workload which justifies posting a liaison prosecutor at Eurojust in the first place. And once the decision has been taken as to whether the liaison prosecutor would be working full-time at Eurojust or whether they would come a few days a month or working half-time, for instance. Now, when it comes to the liaison prosecutor who have been working full-time at Eurojust, they are frankly fully integrated in the structure of the organization. They sometimes also represent a workload which is higher than some member states themselves, so they play a very important role in the handling of cases at Eurojust. And this is also a very important aspect of the organization. Yes, we are an EU agency. We deal primarily with crime committed within the EU among us, but as we know, crime doesn't know any borders. And they are committed also in the outskirts of the EU, primarily. Therefore, our relations to our neighbors are very important, and hence these cooperation agreements and liaison prosecutor. Of course, on the list, you also have a country like the US, which is not really a neighbor, but as you can imagine, who's very important as well when it comes to the commission of cybercrime, for instance, all the IT aspects. There are many aspects related to the US, so that's why it's important to keep this link. So the first question, as we could see earlier, is whether we have a cooperation agreement which is already in force. If it's not the case, then the fallback position for us to transfer personal data is whether there is an adequacy decision, again, adopted on the basis of the law enforcement directive. I'm insisting on this point because I think there is a bit of confusion sometimes whenever we talk about adequacy decisions, because the adequacy decisions can have two different legal bases. One being the GDPR, which of course does not cover law enforcement, the other one being the Law Enforcement Directive, in which case the scope is restricted to law enforcement. So here we have to be clear that we're talking about an adequacy decision which is adopted on the basis of the Law Enforcement Directive. This is also an important aspect for the workshop tomorrow, as you will see. So yes, so again, the additional problem being that so far we do not have any adequacy decision. In order to make an adequacy decision, you need a positive assessment of the Commission finding an adequate level of data protection in the third country. Adequate level of data protection does not mean the same level of protection as in the EU, of course, but the idea is to get as close to the level of protection that we have in the EU as possible. And if it's not the case, as we know, this is the situation when it comes to adequacy decisions, then you need to check whether appropriate safeguards and derogations are available. And the applicable provisions for us are set out in the Eurojust regulation. But of course, this is not the principle. So we need to be careful with these appropriate safeguards. We haven't had any application so far. But whenever the issue will be raised, we'll be extremely cautious, because that's the spirit of appropriate safeguards. Again, the principle is, do we have a cooperation agreement in place already, or is there an adequacy decision? So this is the end of my presentation. I thank you for your attention.